Chapter 3 Court Bonds Fiduciaries, Sec. 41. In the language of surety companies, a fiduciary is one who, under the jurisdiction and supervision of a court of justice, has the care and custody of another's property, holding it in trust. The term includes executors and administrators of estates of deceased persons, trustees, receivers, assignees for the benefit of creditors, guardians and tutors of minors, and committees and conservators of the estates of incompetents. Fiduciaries are always required to give bond with surety for the faithful performance of their duties, and these bonds form one of the most important branches of the surety business. It seems advisable, before beginning a discussion of the underwriting of these bonds, to define, briefly and in a general way, the duties of each of the different classes of fiduciaries, so that the discussion may be the more intelligible. Sec. 42. Executors and Administrators. An executor is a person appointed by a will to administer the estate of a testator, to pay his debts and distribute the assets as directed by the will. An administrator is a person appointed by a court having jurisdiction over estates of deceased persons to perform the same functions with respect to the estate of a person who has died without leaving a will, the distribution, in that event, being made as directed by law. It is the duty of an executor or administrator immediately to take charge of the assets and give notice by publication, in the manner required by law, of his appointment, so that those who have claims against the estate may have an opportunity to present them to the court to be approved and allowed. As soon as practicable, he ought to file with the court an inventory of the assets, and, when the statutory period within which claims may be filed, has expired, he ought, unless the estate is involved in litigation, or he is otherwise delayed, to pay the debts and distribute the balance of the estate to those entitled to receive it. The identical assets may be distributed where practicable, but, if necessary, the executor may, under proper order of the court, sell them and distribute the proceeds. Although it is the duty of an executor or administrator, as soon as practicable, to distribute the estate, and not to hold and invest it, yet, if there should be a necessary delay in winding up the estate, he ought to use reasonable diligence to have the estate yield an income. An executor is not expected to continue a business left by the decedent, unless specially authorized to do so by the will, and if he does so, and loses any part of the assets, he and his surety will be liable. Likewise, an administrator ought not to continue a business unless authorized to do so by the court, and then only when the court has specific statutory authority to make the order. Sec. 43. Administrators de bonis non. Where an administrator dies, resigns, or is discharged before the administration is complete, it is the duty of the probate court to appoint a successor, who is called an administrator de bonis non. It is his duty to complete the administration in the same way as the first administrator would have been required to do. Sec. 44. Administrators cum testamento annexo. Where a man leaves a will but does not name an executor, it is the duty of the court to appoint someone to administer the estate. Such a one is called an administrator with the will annexed, cum testamento annexo, or C.T. A. His duties are the same as if he had been named in the will. Sec. 45. Administrators cum testamento annexo de bonis non. Where an executor dies, resigns or is discharged before the administration is complete, it is the duty of the probate court to appoint a successor, known as the administrator with the will annexed de bonis non, cum testamento annexo de bonis non or C.T. A. D. B. N. It is the duty of such an administrator to complete the administration in the same way as the executor would have been required to do, paying the debt and carrying out the provisions of the will. Sec. 46. Temporary or special administrators or administrators pendenti lite. When a will is offered for probate, and its validity is contested, the person named in the will as executor will not be permitted to qualify as such until it has been decided that the will is valid. In the meantime, the court will appoint someone to preserve the estate, and where, in a case of intestacy, there is a contest as to who is entitled to be appointed administrator, or whether there is any other reason why a regular or permanent administrator cannot be appointed, the court will likewise appoint someone to look after and preserve the estate. Such an appointee is known as a temporary or special administrator or an administrator pendente light, depending upon the language of the statute regulating the matter or the usage in the particular state. The duty of such an administrator is merely to preserve the estate. The court may authorize him to convert into money any part of the estate which may be perishable or which is likely to depreciate in value. But generally he has no right to pay any debts or to distribute any of the assets or to carry on any business that may have been left by the decedent. His duties are simply to preserve the estate pending final decision as to the validity of the will or as to who is entitled to be administrator. Sec. 47. Trustees. Any person who holds property in trust for another is a trustee. In that sense, trustee has the same meaning that we have given to the word fiduciary. In the language of surety companies, trustee is used in a more restricted sense, including only trustees strictly so called. Indeed, it is generally limited to trustees of express trusts, that is to say, trusts created by an instrument in writing, such as a deed, or will, and furthermore, it is limited to such trustees of express trusts as administer their trusts under the jurisdiction of a court of chancery. The first and most important duty of such a trustee is to study and become thoroughly familiar with the provisions of the instrument, and thereafter to follow them out explicitly. In cases where there are no directions in the instrument, or where the directions are ambiguous, uncertain, or incomplete, he ought to apply to the court for directions. In this connection, it is to be remembered that a court of chancery is a court of general jurisdiction, and that a grant of authority from such a court, unless appealed from and reversed, will generally protect the trustee and his surety from a liability for any loss that may result. Sec. 48. Trustees, commissioners, guardians and administrators to sell property. When a court of chancery orders the sale of real estate or personal property, it is usual, and indeed necessary, to appoint a trustee, or commissioner to make the sale. It is the duty of such appointee to sell the property either at public or private sale, as may have been ordered, and upon the terms fixed by the decree. He is then to apply the proceeds in accordance with the orders of the court, either investing them or distributing them to the proper persons. The same duties are incumbent upon an administrator, a guardian or other fiduciary, who may be authorized by a court to make sale of real estate or personal property. In all such cases it is important that the sale be made to a third person, in good faith, for the best price that can be obtained and in the manner and upon the terms fixed by the order. The proper disposition of the proceeds will depend upon the order of the court, and it should be strictly followed. Sec. 49. Receivers. A receiver is an officer of a court of chancery, through whom the court, in the exercise of its jurisdiction, takes possession of property which is the subject of a suit, preserves it from spoliation, waste or destruction, and ultimately disposes of it according to the rights of those entitled thereto. The most frequent occasion for the appointment of a receiver is for a business which is insolvent and where the assets are in danger of spoliation or waste. The purpose of the appointment, however, is not necessarily at once to wind up the business and distribute the assets to the creditors, but the receiver may be authorized by the court to continue the business. Being a court of general jurisdiction, its order to continue the business will be a complete protection to the receiver, even though a loss should be the result, provided, of course, the receiver exercises reasonable care and diligence to make the business successful, complies with all the orders of the court and makes the required reports to the court from time to time while the business is being conducted. The receivership will be terminated finally by paying all the debts and restoring the property to the original owners, or selling it and distributing the proceeds to the creditors. Sec. 50. Receivers and trustees in bankruptcy. When, under the national bankruptcy law, a man is adjudicated a bankrupt by the United States District Court, and sometimes before he is so adjudicated, it is the duty of the court to appoint a receiver to take charge of the assets of the bankrupt. The duty of the receiver is merely to hold the assets intact pending the election by the creditors of a trustee, although the receiver may be authorized to convert into money any assets that may be of a perishable nature. The duty of the trustee is to convert the estate into money and distribute it to the creditors, being governed in all matters by the terms of the bankruptcy law and the order of the court. Sec. 51. Assignees for the benefit of creditors. A person who is unable to pay his debts may file his petition in bankruptcy, give up all, or practically all, of his property, and, in a proper case, get a discharge from all his debts. This is the usual practice, but there are cases where the insolvent debtor prefers to make an assignment for the benefit of creditors, that is, convey all his property to a third person, with directions to convert it into money, and after paying expenses, to divide it among the creditors. The grantee in such a conveyance is known as an assignee for the benefit of creditors. It is his duty to administer the trust in the manner pointed out in the deed of assignment, and in order that he and his surety may be protected, as far as possible, from the consequence of his errors, he ought to submit himself and the estate to the jurisdiction of a court of chancery and obtain its directions in all matters pertaining to the administration of the trust. If he does not do so, he and his surety not only take the risk of errors, but the assignee will not be required to file periodical accounts, nor can the surety obtain a statutory release, nor will the surety have any of the other rights and remedies in such cases provided. Consequently, the risk of the surety is greatly increased by an administration independent of a court of chancery. There is still another danger to which an assignee and his surety are subject. The making of an assignment for the benefit of creditors is in itself an act of bankruptcy, that is to say, it gives the creditors the right to have the assignor adjudicated a bankrupt and to have the estate administered by the United States District Court, which is the bankruptcy court. If after an assigned estate has been partially administered, the assignor should be thrown into bankruptcy, the trustee in bankruptcy would be entitled to the entire estate, just as it existed at the time of the assignment, and would of course be bound to distribute it in accordance with the bankruptcy law. If therefore, the assignee had disposed of the estate, or any part of it, contrary to the provisions of the bankruptcy law, even though in accordance with the state law governing assigned estates, he and his surety would be bound to make good the portion thus improperly distributed. This is not merely a theoretical danger, for one of the companies sustained a single loss of over $17,000 from this cause. In this connection, it may be well to note that assignments of this kind are made, as a rule, only where the assignee wants to give some special preference that would be contrary to the bankruptcy law, or obtain for himself some advantage that would not be permissible under that law. Any such preference or advantage would necessarily be to the disadvantage of the general creditors, and therefore it is quite probable that the assignor will be put into bankruptcy, and a surety should not, as a rule, sign these bonds unless the applicant has a very considerable amount of property. Sec. 52. Guardians and tutors of minors. A guardian is the person appointed by a probate court to manage the estate of a minor, the latter being known as the ward. In Louisiana, the person who manages the estate of a minor is called a tutor. It is the duty of the guardian or tutor to take charge of the estate and keep it invested, in the manner provided by law and the orders of the court, until the minor reaches his majority. It then becomes his duty to file a final account, turn over the estate to the ward, and obtain a release of himself and his surety. He should also, during the minority of the ward, file periodical accounts of his administration, as required by law. If it is necessary for the guardian to expend any part of the estate, either principal or income, for the maintenance or education of the ward, or for any other purpose, he should obtain an order of court authorizing him to do 80. Otherwise he and his surety may be held liable for the money so expended. In some states the guardian has a discretion to use the income for the maintenance of the ward, but it is not the general rule, and unless the statutes expressly authorize the guardian to do so, the surety should not permit it. Sec. 53. Committee, conservator or curator. An insane person, or person non compos mentis, has no status in law, and like a minor, cannot legally act with respect to his own property. It is therefore necessary for the courts to appoint someone to act for him. Such person is called a committee. In most of the states, although in Illinois, and some others, he is called conservator, and in Louisiana, he is called a curator. His duty is to manage the estate, under the order of the court, and keep it properly invested. He should file periodical accounts of his administration, and, if it becomes necessary to use any part of the estate for the maintenance of the incompetent, he should obtain an order of court authorizing him to do so. Sec. 54. The underwriting of bonds of fiduciaries. In the preceding pages, all of the important kinds of fiduciaries have been mentioned, and a brief sketch has been made of some of the duties and liabilities peculiar to each class. Consideration will now be given to the duties and liabilities which are common to nearly all fiduciaries and to the nature of the risk that will be assumed by the surety, and as in the case of fidelity bonds and bonds of public officers, the subject will be treated from the two standpoints of the personality of the applicant, and the nature of the position. Sec. 55. The personality of the applicant. In the consideration of applications for bonds of fiduciaries, surety companies are confronted with the personal element in much the same way as with fidelity and public official applications. The duty of a fiduciary includes the custody and care of money and property of others, and it is necessary to be satisfied as to his probable honesty. It is not feasible, however, as a rule, to investigate his antecedents, environment, character, habits and record of service to the same extent as with fidelity applications. Generally the only sources of information are the applicant's attorney and the 3 or 4 persons to whom the applicant refers. In making an investigation through these sources, the underwriter will be governed by the same rules and principles as in the case of fidelity and public official applications. However, in many cases an almost immediate decision is necessary. 80. That practically no opportunity to make an investigation is offered. Applicants will then have to be accepted or rejected on their general reputation and the statements of their attorneys, but this can safely be done only where the surety obtains joint control of the assets so that they cannot be misappropriated without the consent of the surety. Indeed, as we shall see, it is getting to be the uniform practice of bonding companies to require all applicants for bonds of this kind to give the surety joint control of the assets. Sec. 56. Personality, as affected by standing of his attorney. There are few, if any, cases in which fiduciaries can successfully perform their duties without the continuous aid and advice of an attorney, and they have a right, at the expense of the estate, to employ counsel to represent them. The character of an applicant can often be determined by the standing of his attorney, and furthermore, the character and standing of the attorney, and the extent of his control over the practical management of the estate are important considerations in judging the desirability of a particular risk. Where a careful attorney of well-recognized ability and integrity has the actual management of the estate, the possibility of loss is greatly reduced. And where the applicant is not represented by an attorney of good standing, the business should be declined unless strict joint control is secured, and even then, it is not altogether desirable, as it is always unsatisfactory to deal with an attorney in whom one has not reasonable confidence. Sec. 57. The nature of the position. In general, the bond of a fiduciary is not, like a fidelity bond, limited to cover only certain definite and specific acts of the principal, but, like the bond of a public officer, is conditioned for the faithful performance of all his duties. The duties of the several kinds of fiduciaries have in a general way been indicated, and some of the liabilities peculiar to each class have been pointed out. It is next in order to consider the duties and the liabilities, which are common to nearly all fiduciaries, and to which they and their sureties are subject. In the meantime, however, let us consider their opportunities for misappropriating the assets and the means of limiting this opportunity. Sec. 58. Opportunity for misappropriation. Joint control. A fiduciary, under the law, has sole control of the assets of the estate, so that, in the absence of interference by the surety, his opportunity is limited only by the amount of the estate. However, it is now the very general practice of surety companies to require all applicants for bonds of this kind to give the representative of the surety company joint control of the estate. Joint control, as the term here used, contemplates that the funds are to be put in a bank and the securities in a safety deposit box, in the name of the estate subject to the joint order of the principal and the company's representative, so that they cannot be withdrawn except upon the counter-signature of the latter. And it is important, not merely to have the applicant agree to give joint control, but to obtain from him a letter addressed to the bank, or other custodian of the funds and property of the estate, consenting that such custodian may deliver the property only upon the counter-signature of the surety's representative. In the keen competition for business, Surety agents often waive joint control in order to get a particular bond or the business of a particular man, but it is a bad practice. In the great majority of cases, most men being honest, joint control could of course be waived with perfect safety, but inasmuch as it is impossible accurately to pick out these cases in advance, and inasmuch as losses occur where they are least expected, it is suggested that joint control be made the universal rule. I have in mind a case in my own experience where a man of the very highest standing in the community and of reputed wealth, one whom anybody would have trusted, applied for an administrator's bond and suggested that joint control be waived. Considering the business gilt-edged, and desiring to retain the applicant's goodwill, having future business in view, I readily consented, to find about a year later that he was a defaulter for a very large sum, and that of the $5,000 received by him as administrator, he had on hand only about $25, the balance having been misappropriated. The records of the companies are full of such cases, and there ought to be none. A surety company is not paid for taking any risk, but merely for the use of its name and credit, and when the bulk of the risk can be avoided so easily, it should be done. Joint control should be the universal rule. However, in the case of receivers and trustees in bankruptcy, the referee, who is an officer of the court, is expected to and generally does exercise joint control of the money and securities of the estate, requiring them to be deposited in a bank selected and designated by the court. In that event, it is of course unnecessary for the surety company to exercise joint control, but in some jurisdictions the referee acts in this respect, particularly in cases where the trustee is to conduct the business of the bankrupt, which would require the frequent issuance of checks. If in any particular case, the referee will not effectively exercise joint control, then the surety should insist upon it. Sec. 59. Duties and liabilities. In general, a fiduciary, as we have seen, is bound faithfully to perform his duties, and this necessarily subjects him and his surety to certain liabilities, against which they must, at their peril, protect themselves. As a rule, surety companies do not leave the fiduciaries whom they have bonded to act entirely upon their own judgment, but endeavor, so far as may be reasonably possible, to see to it that they properly perform their duties, and in many cases, exercise joint control of the estate, to the end that there may be no loss under the bond. In the ensuing pages therefore, the principal duties and liabilities of fiduciaries will be indicated, and some suggestions will be made as to the proper method of performing those duties and thereby avoiding the liabilities. Sec. 60. Possession of the trust property. The first duty of a fiduciary is to secure possession of the trust property. If it consists in part, of notes, bonds, policies of insurance and the like, he should notify the promisors or makers of the instruments, and should obtain actual possession. And the transfer to him should be made in such a way as to identify the instruments as a part of the particular trust estate. Likewise the fiduciary should proceed at once to collect the debts due the estate. There is no fixed time within which the debts must be collected, but he must use due diligence under the circumstances. If the trust estate consists in part of real estate, he should see that the record title is put in his name in his fiduciary capacity, or in the name of the beneficiary, as the circumstances of the case may require, and he should take possession of it, either actual or constructive. If it is under lease, he should take constructive possession of it by compelling the tenant to acknowledge him as the landlord and to agree to pay rent to him. If there is no tenant, he should take actual possession. If the beneficiary is in possession, under the terms of the trust, he need do nothing, as under these circumstances, the possession of the beneficiary is the possession of the trustee. Sec. 61. Filing of inventory. As soon as the estate has come into the possession of the fiduciary, he should make an inventory, and file it with the clerk of the court having jurisdiction. Inasmuch as the inventory shows the assets for which the surety is liable and shows the form in which they exist, it will aid the surety in deciding what steps the fiduciary ought to take, and in guiding him in the performance of his duties. As soon as possible therefore, the surety should obtain a copy of the inventory. A simple request to the attorney will generally bring it. Sec. 62. Conversion of estate into proper form. Speaking generally, fiduciaries are appointed either to distribute the estate to those entitled to it, or to hold and invest it so that it will produce the largest income that is consistent with absolute safety of principle. Where it is the duty of the fiduciary merely to divide the estate, as is the case with executors, administrators, receivers, assignees and the like, it is generally necessary to convert the estate into money, so that it may be properly divided, although, in the case of estates of deceased persons, distribution can sometimes be made of the specific property. In any event, the purpose of such an appointment is to ascertain what persons are entitled to the property, and, with all reasonable dispatch, to distribute it to them, and not to carry on any mercantile business belonging to the estate, or otherwise attempt to make money for the estate. In the case of estates of deceased persons, it is the universal rule, that, in the absence of express direction, either in the will or by a proper order of court, the executor or administrator should not attempt to carry on the business of the decedent, but should immediately close it up and convert it into money. And it is to be borne in mind that the courts having jurisdiction over the estates of decedents, being courts of limited jurisdiction, and having only the powers given by statute, generally have no power to authorize an executor or administrator to conduct the business. In the absence of express statutory authority, such an order would be void, and would not relieve the executor or administrator and his surety from a liability for any loss that might result. When the estate of a decedent consists of a running business, the surety should not sign the bond of the administrator unless it is clearly understood that the business will immediately be closed and the stock sold. In the case of receivers, assignees and the like, who are under the jurisdiction of courts of chancery, the court may, and often does, authorize them to continue the business until the further order of the court. But the business should not be continued without such express direction, and then the order of the court should be strictly followed. Where the trust estate is to be held for investment, the form in which it exists at the beginning of the trust, is often, in part at least, not adapted to trust purposes. An individual may be engaged in business, in a partnership, or in the management of his property for the purpose of gain, and rarely is his property permanently invested without some regard to speculative value. Where a trustee receives an interest in a partnership, in a business, or in speculative or unproductive property, or in fact in any property in which he would not be authorized to invest under the terms of the instrument or prevailing law, he must proceed immediately to convert all such property into proper investments. In the absence of a contrary direction, vacant land, even if it has a large prospective value, should be converted, since trust property should yield an income. All undivided estates should be converted, since the trustee has not the absolute control over them. Leaseholds and all wasting investments, such for example as stock in mining companies, where the principal is being consumed, should be converted into trust investments. Loans on personal security should likewise be converted. And the trustee should act promptly in making these conversions, for if he delays beyond a reasonable time, he and his surety will be liable for any loss of the property. On the other hand, if the donor of the trust has provided for the continuation of the business, or the holding of the particular property, or if he has left his property prudently and permanently invested, not with a view of speculation, the trustee should not convert it, unless perhaps the investments are such as he is forbidden to make under the terms of the trust or the law. Sec. 63. Payment of debts. If the estate is liable for the payment of debts, as is always the case with estates of deceased persons, and with bankrupt and insolvent estates, it is the duty of the fiduciary, not only to pay the known debts but to give notice by publication, in the manner provided by law, of his appointment, to the end that all who have claims against the estate may have an opportunity to be heard. As a rule, no debts should be paid until after the expiration of the time within which claims may be filed, for if some should be paid in full, and subsequent claims should make the estate insolvent so that the creditors would not be entitled to full payment, there would be an overpayment for which the fiduciary would be liable. Generally, however, there is no objection to paying individual items which have a clear priority, such, for example, as taxes, and, in the case of estates of deceased persons, the funeral expenses of the deceased. Where there may be more than one item in a particular class, payment should not be made until after the expiration of the time for filing claims, as there may be enough items in that class to exhaust the estate and leave a deficit after the expiration of the time for filing claims, and if there is enough money in the estate to pay all claims, it is proper to pay such of them as have been found by the court to be proper, retaining on hand enough to pay any that may be disputed. If there is not enough to pay all, including those disputed, then none should be paid, or they should be paid only pro rata, for if the estate should be found insufficient and some have been paid in full, there will be an overpayment for which the fiduciary will be liable. Sec. 64. Investment of funds. As we have seen, fiduciaries are divisible into two classes: those whose duty is merely to distribute the estate and those whose duty is to hold and invest it. The first class embraces executors, administrators, receivers, assignees and the like, and the second class includes guardians and tutors of minors, committees, curators, and conservators of incompetents and certain classes of trustees. When a fiduciary of the second class has obtained possession of the estate, and has converted into money so much of it as is necessary to be converted, his next duty is to invest the proceeds. In doing so he must invest them securely so that the principal will be preserved, and he must invest them productively so that they will yield the current rate of interest. If there are directions in the instrument creating the trust as to the manner of investing the funds, those directions must be followed, for the creator of a trust may undoubtedly specify the kind of investments that may be made with the trust funds. In the absence of such directions, the fiduciary must be governed by the law of the state in which the trust is being executed and the rules of the court having jurisdiction over the estate. If there is no law or rule of court in relation to investments, a fiduciary can safely follow the rules prescribed for the investment of funds of savings banks in the particular state. And if there is no such rule, or if it is not practicable to follow that rule, fiduciaries must be governed by sound discretion and good faith, having in view, not speculation, but a permanent investment, considering both probable income and safety of principal. They must observe how men of prudence, discretion and intelligence manage their own affairs, not in regard to speculation but in regard to the permanent disposition of their funds, considering the probable income as well as the probable safety of principal. This is known as the American rule, but the courts and legislatures in the various states have, from this rule, evolved very different results. Having reference to the classes of securities in which trust funds may be invested, the courts of New York have established a rule which seems to be fairly satisfactory and reasonably safe, and which should perhaps be followed in other states, unless a more liberal rule has been clearly established by proper authority. The New York rule is that trust funds ought to be invested in government, state or municipal bonds, first mortgage bonds of corporations and first mortgages on real estate. Other states, including Massachusetts, hold that a fiduciary may also invest in stocks of business corporations such as banks, railroads and manufacturing companies, and in notes of individuals secured by the stock of such corporations, provided the corporations have acquired, by reason of the amount of their property and the prudent management of their affairs, such a reputation that cautious and intelligent persons commonly invest their own money in such stocks as permanent investments. There is no definite rule for determining who are cautious and intelligent persons within the meaning of this rule, nor when their investments are intended to be permanent and not speculative. At best, such securities are liable to fluctuate in value, and are therefore more or less speculative. It is hardly necessary to add that the following kinds of investments are everywhere disapproved: loans on personal security, whether of one or more persons; investments in business ventures, whether in trading or manufacturing or otherwise; second mortgages and mortgages on leasehold property, unproductive real estate, and all investments of an untried or speculative nature. A fiduciary gains nothing by making such investments, for he must account for all profits and is responsible for all losses. It is however not enough that a fiduciary select securities from one of the classes that are recognized as proper investments. He must also exercise a sound discretion in selecting investments within the authorized classes. He must exercise the same degree of intelligence and diligence that a man of average ability would exercise in making his own investments. The rule is that the question of whether there was a sound exercise of discretion is to be determined according to the state of facts as they existed when the investment was made, and not in the light of later developments. But it is well known that the later developments, if they show a loss, are likely to influence the court and jury in determining the propriety of the investment. A fiduciary therefore owes it to himself and his surety to use great care and conservatism in investing the funds under his control. The danger of erring on the side of ultra-conservatism is small, for there are few, if any, cases where a fiduciary has been criticized for making investments so conservative that they do not produce an acceptable rate of interest. Before investing in bonds, he ought to consult a responsible and conservative bondhouse, and likewise, in making mortgage loans, he ought to consult a reliable expert on real estate values. He has a right to get such expert advice, and if there is any incidental expense, to charge it to the estate. In practice, the commission on the sale and purchase will generally pay for the expert advice of the broker. The point is to select a competent and reliable broker. It is also the duty of the fiduciary to exercise due care to keep the estate invested, and if he is negligent in this respect, he will be held liable for the income he might have earned. Sec. 65. Care of the trust property. Having obtained possession of the trust property, having converted into money so much of it as is necessary to be converted, and having paid the debts and invested the cash, it is the duty of the fiduciary to take care of the assets of the estate, and in so doing, to use reasonable skill, prudence and diligence. We have seen that, if a public officer deposits public money in a bank and the bank fails, he and his surety will be required to make good the loss, even though the utmost care was used in the selection of the bank. It is not so with the fiduciary. If he uses reasonable care in the selection of the bank, if, under the circumstances, a reasonably prudent man would have put his own money in the bank, he is not liable for loss resulting from the failure of the bank. As we shall see, however, in order for the fiduciary to be thus relieved, it must appear that the money was deposited in the name of the estate. The securities should be kept in a safe deposit box, and the box should be rented in the name of the estate. If the securities should be kept in the home or office of the fiduciary, or even in an ordinary iron safe, and should be lost, the fiduciary and his surety would probably be held liable for the loss. The improvements on the real estate should be insured and the taxes thereon should be paid. It should be put in condition to be rented and should be kept in repair, and if, in so doing, a substantial sum of money is necessary, an order of court should be obtained. Chattels are generally converted into money, but if, by the terms of the trust, they are to be held as a part of the estate, they should be put in as safe a place as is reasonably possible, and, if practicable, should be kept insured. Sec. 66. Trust property to be kept separate. A fiduciary should not, under any circumstances, commingle the trust property with his own, but should keep it separate so that it can always be identified as trust property. The bank account should be kept in the name of the estate, or in the name of the fiduciary, followed by such language as to show that the money belongs to the estate, as for example, John Smith, trustee under the will of Henry Jones. All the securities belonging to the estate should, if possible, be placed in the name of the estate so that they cannot be transferred to a third person except upon the signature of the fiduciary, and the safe deposit box in which they are kept should be rented in the name of the estate. Title to land, and all mortgages, should of course be taken in the name of the estate or of the beneficiary, but never in the name of the fiduciary, in his individual capacity. Chattels should likewise be kept separate from the individual property of the fiduciary and identified as a part of the estate. The importance of the separation and identification of the trust property ought not to be underestimated by the surety. In the first place, the fiduciary is more likely to use the trust property for his own account if it is mixed with his own or stands in his individual name, and, in the second place, even if the fiduciary has no intention of misappropriating any part of the estate, loss may nevertheless be suffered by the surety, in at least two ways. 1. The rule is that if a fiduciary uses reasonable care in the selection of a depository for the funds, and deposits them in the manner above indicated and not in his individual name, he and his surety will be relieved of liability for loss resulting from the failure of the bank. But if he deposits the funds to his individual credit, whether commingled with his own or not, it is considered a technical conversion of the funds to his own use, and, if the bank should fail, he and his surety would be liable for the resulting loss, even though the greatest care may have been used in the selection of the depository. 2. If the fiduciary should become insolvent and be put into bankruptcy, with the trust funds standing in his individual name, his general creditors would be entitled to the funds as against the beneficiaries of the trust, and the surety would be compelled to make good the loss. If, on the other hand, they had been carried in the name of the estate, the creditors would not, of course, have been entitled to them. If the other property of the estate could not be identified as trust property, it likewise would go to the general creditors. Sec. 67. Money to be kept under exclusive control. The effect of joint control by surety. If a fiduciary deposits the money of the estate in such manner that it is not under his exclusive control, as where it cannot be withdrawn without the concurrence of other persons, he and his surety will be liable for loss resulting from the failure of the bank. This rule is based on the principle that it is the duty of a fiduciary to withdraw the money from the bank upon the slightest indication of danger, and that he cannot perform this duty promptly if he is hampered by the necessity of procuring the concurrent action of other persons. And this rule has been held to apply when a surety company, for the better preservation of the estate, requires and exercises joint control of the funds so that they cannot be withdrawn except upon the countersignature of its representative. But of course, it can apply only in those states where joint control by a surety is not recognized and approved by statute, and it so happens that in many of the states such approval by statute has now been given. In states where joint control by the surety has not been approved by statute, it should be borne in mind that when a surety company elects to accept the protection afforded by joint control, it, at the same time, becomes a guarantor of the continued solvency of the depository. Sec. 68. Periodical accounting. It is the duty of all fiduciaries, periodically, to file reports and accounts of their administration, showing what assets have been received and why disposition has been made of them. The time when such periodical accounts should be filed is usually regulated by statute or rule of court, but the general rule is that an account should be filed at least once a year. Where a fiduciary, under order of court, is conducting a business belonging to the estate, he should report much more frequently, say once a month, in order that the court may determine whether or not the business should be further continued. This is generally regulated by the order authorizing the continuance of the business. The surety should insist that the proper reports and accounts be rendered so that he may be advised of any neglect or improper conduct on the part of the principal. Sec. 69. Distribution of the estate. It is the duty of a fiduciary to distribute the estate as soon as the proper time comes for him to do so, and if he holds the estate an unreasonable length of time after distribution should be made, he subjects himself and his surety to certain extraordinary risks. The rule is that a fiduciary is bound to account for what was, or ought to have been, on hand when final distribution was due, and if, after that time, a part or all of the estate should be lost, even without his fault, he and his surety would ordinarily be liable for the loss. If, for example, the bank in which the money was deposited should fail, he would be liable for the loss, notwithstanding he may have used due care and had deposited the money in the name of the estate. So also, if an investment, which was proper when made, should depreciate in value or become worthless after the time when distribution was due, he would be liable. It is not possible to state in advance when distribution in each case should be made, but it may be said, in a general way, that estates of deceased persons can ordinarily be closed within a year, and that much time is always allowed. There are, of course, many cases where more than a year is necessary, but as soon as the debts are paid and the distributees ascertained, the distribution should be made. The estate of a minor should be transferred to him as soon as possible after he reaches his majority. A bankrupt or insolvent estate should be distributed as soon as the assets have been converted into money and the number and amount of the claims have been ascertained. Where a considerable part of the assets have been converted, a partial distribution may be made. A fiduciary must not only distribute the estate promptly when distribution is due, but he must, at his peril, distribute it properly. If he distributes the wrong amount or pays it to the wrong person, he must bear the loss. The fact that he has been diligent or has taken advice, will not save him. The only protection is to obtain a decree of distribution, and he should see that all parties in interest are parties to the suit so that the decree will be binding upon them. If there is any doubt as to whether all parties have been joined, he may require the distributees to give bond to indemnify him and his surety against loss, and the surety should for its own protection see that such bonds of indemnity are given. Likewise the fiduciary must, at his peril, pay the distributive shares to the identical persons named in the decree, or to their proper representatives. The fact that he pays on a forged order, an invalid assignment or a power of attorney which, unknown to him, has been revoked, will not protect him. He must pay the share of a minor, or other incompetent, to his legal representatives and no other. Sec. 70. Liability of surety for debts due by fiduciary. If a fiduciary is indebted to the estate committed to his care, the amount of the debt automatically becomes assets of the estate. No formal transfer from himself individually to himself in his fiduciary capacity being necessity. He will be required, as fiduciary, to account for the amount of the debt as so much cash, and this entirely irrespective of his ability, in point of fact, to pay the debt. Inasmuch as the surety for a fiduciary is liable for all assets that come into the hands of the principal, and inasmuch as a debt due by the fiduciary to the estate is treated as an asset, it follows that the surety for such a fiduciary guarantees the continued solvency of the principal and his ability to pay the debt. This is an extraordinary risk which a surety company ought not to assume unless the fiduciary is abundantly able to pay the debt. The signing of the bond is equivalent to endorsing a note of the principal for the amount due the estate. Sec. 71. Liability for acts in excess of authority. While a fiduciary must be diligent to perform the duties imposed upon him by law, he must, at the same time, be careful not to exceed his powers. He is bound to observe the limitations of the law, and, if loss result to the estate from an act in excess of his powers, he and his surety will be liable. If, for example, he sells any of the trust property without having power to do so, or makes an unauthorized conversion, he may be compelled to replace the property in kind or make good any subsequent increase in its value. If he makes an unauthorized payment, he will be compelled to replace the amount so paid. He can generally protect himself by procuring an order of court, and he should not sell any of the property, convert any of it into money, make any payment, or do any other act that may result in loss, without obtaining such an order, and the terms of the order should be strictly and exactly followed. If the court is one of limited statutory jurisdiction, he should be careful to ascertain that the court has jurisdiction to make the order. Where the directions in the instrument creating the trust are clear and explicit, it is not so important to obtain an order of court. But no harm will be done, and it is advisable to do so, particularly if there is any possibility of a different construction of the instrument. Sec. 72. The exercising of joint control by surety. We have seen that it is fast becoming the uniform practice of surety companies to require all fiduciaries to give the representative of the company joint control of the assets of the estate. Joint control is desirable because, first, it will prevent the fiduciary from appropriating the estate to his own use, and, second, it will enable the surety, in a measure, to see that the principal properly performs his duties and that he pays out the estate only for proper purposes, purposes which are authorized by law, and which the court having jurisdiction has approved, or is legally bound to approve. This, however, is not a merely perfunctory matter of countersigning checks. It requires considerable knowledge and care on the part of the surety's representative, as shown by the fact that one company, in making a partial examination into the causes of its losses during the year 1912, found, in the cases examined, a loss of nearly $20,000 directly attributable to the fact that its representatives permitted money of which they had joint control to be improperly withdrawn and expended. The experience of the other companies is probably just as bad, or nearly so. In exercising joint control, the surety company's representative should see that the estate is converted into the proper form, that the debts of the estate are paid, but only at the proper time and in the proper order, that the funds are properly invested, that any cash that may be on hand is put in a carefully selected bank, the securities in a safe deposit box, and that the other assets are properly cared for, that the trust property is kept separate and identified as trust property, that the assets are properly distributed, and that the principal does not exceed his authority. In order for a company to be perfectly safe in the handling of its joint control cases, it would perhaps be necessary to put the matter in charge of an attorney, especially trained in the handling of estates. This it is not always practicable to do, but if those who are required to exercise joint control will keep in mind what has been said in the preceding pages regarding the duties and liabilities of fiduciaries, and will use their common sense and some care, there ought not to be any difficulty. There are 3 tests which should be applied to every payment the surety is asked to authorize. 1. Is it a proper payment in the opinion of the surety's representative? If the payment is for investment, is it a proper investment? If for the payment of a debt, is the debt a proper one to be paid at the time? If a distribution, is it being made at the proper time and to the proper person? Is the principal acting within his authority? 2. Has the payment been approved by the court having jurisdiction? Ordinarily such approval should be a condition precedent to the countersigning of any checks, and this rule applies to the following payments, which are sometimes made without an order of court. A. The payment of the funeral expenses of the deceased. However, this expense is generally the first preferred claim against the estate, so that if there is any particular occasion for haste, it is reasonably safe to waive the order of court. B. Any special statutory allowance in favor of the widow or children of the deceased person. If, however, the right to the payment is absolute or depends solely upon the judgment or discretion of the fiduciary, the order may be waived. C. All claims against the estate, whether preferred or not. None of the claims should be paid until after the expiration of the time within which claims may be allowed. Then an account showing the claims to be paid should be filed, and upon approval of the same by the court, the debts may be paid. D. All payments for the support and maintenance of the beneficiaries of the estate. It is necessary to be careful in such cases, for guardians of minors and conservators of the estates of incompetents often assume they have the right to support the beneficiary out of the estate when in fact they have not. E. All investments, unless the funds are to be invested in a security which has already been approved by the court, on which the court is bound to approve. 3. Has the payment been expressly approved by the attorney for the estate? This should also be a condition precedent to the countersigning of any check. This is necessary not only where an order of court is waived, but also for the purpose of determining that any order that may have been issued is being properly interpreted. Where the attorney is a man of reasonably good standing at the bar, his approval may be permitted to carry considerable weight, although it cannot be absolutely relied upon in all cases, and it is often of advantage to call his attention to any apparent irregularity or impropriety in the payment. The ordinary attorney, not having come directly in contact with the hard knocks to which surety companies have been subjected, does not realize the importance of keeping strictly within the letter of the law. It is really astounding, in the light of the experience of surety companies, to note the apparent freedom with which good attorneys advise their clients who are fiduciaries to ignore or disobey the law. A good surety man is generally a safer advisor than an attorney who has not been specially trained in the handling of estates. All 3 of these tests should be applied as far as may reasonably be possible. In some cases, it may not be feasible to require the express approval of the court, but in no event should any payment, about which the surety's representative has any doubt, on which has not the active and express approval of the attorney, be allowed, and the order of court should not be waived unless there is some good reason for it, and unless the ability and good faith of the attorney are undoubted. Sec. 73. Substituted surety. In the foregoing treatment of the subject of bonds of fiduciaries, it has been assumed that the application for the bond will be made at the time of the appointment of the fiduciary and before he begins to act as such. It is considered bad policy to execute a bond for a fiduciary who has previously been acting under another bond. The extra hazards in such a case may be summarized as follows. 1. The bond may be construed to cover the entire time during which the fiduciary has been acting as such. so that the surety may be held liable for existing as well as future defaults. 2. Even if the bond should not be construed to cover the entire period, it is difficult in many cases to tell just when a default was committed, and the chances are that if the first surety should not be solvent, the substituted surety would be held liable for any default that might be found to exist, even though it may be thought that the default occurred before the new bond was executed. 3. The fact that a new bond is desired is evidence, either that the former surety was suspicious of the principal and obtained a statutory release, or that the beneficiaries became suspicious and asked for an additional bond for their protection. Neither of these suppositions is necessarily true, but the presumption is in favor of the truth of one or the other of them. On the whole, therefore, it is considered the part of wisdom to decline all such applications, unless it is shown positively that the estate is intact at the time and that no suspicion of wrongdoing attaches to the applicant. Joint control should, of course, be required in such cases. Sec. 74. Termination of liability. The bond of a fiduciary is a continuing obligation, that is to say, unless it is terminated in the manner provided by law, it will continue in force so long as the principal continues to act in his capacity as fiduciary. The fact that the principal may file a new bond, or fail to pay the annual premium provided for in his contract with the surety, will not release the surety from liability. And furthermore, inasmuch as probate courts having jurisdiction over the majority of fiduciaries are ordinarily courts of limited jurisdiction, with the right to exercise only the powers that have been given them by statute, such courts have no right, in the absence of an express statutory provision, to relieve a surety from a liability, even though a new bond with another surety be required and given. And if there is a statutory provision authorizing the court to release the surety, the statute must be strictly followed, or the order granting the release will be void. As a matter of fact, the statutes of nearly all the states do provide that sureties on the bonds of fiduciaries may, under certain conditions, obtain a release from future liability, remaining liable always for any default that may have occurred prior to the date of the release. The statutes in the several states are by no means uniform, but the method of procedure generally prescribed is for the surety to file, with the court in which the bond was filed, a petition asking to be relieved of future liability. The court is authorized, or required, upon such petition, to order the fiduciary to account and file a new bond, and upon the filing and approval of the account and the new bond, the court is authorized to enter an order releasing the surety from a liability for the future acts and defaults of the principal. If the principal fails to account and file a new bond, in response to the order of the court, he may be attached for contempt of court and may be removed. In some states, the application of the surety for a release will be granted as a matter of right, that is to say, the court is bound, upon the filing of the petition of the surety, to make the necessary orders looking to the release of the surety. In other states, the release will be granted only when the surety alleges and proves, to the satisfaction of the court, a reason for his request, such as, that the principal is mismanaging the estate or that the surety is in danger of loss. When the statute gives the surety an absolute right, upon application, to be relieved of future liability, it is reasonably prudent to take that fact into consideration in passing upon applications. But where the granting of the release is in discretion of the court, to be exercised only upon cause shown, the provision is not of much practical value. The court will ordinarily not grant the petition unless there is an allegation and proof of mismanagement, and it is generally not wise for a surety to allege and prove that the principal has dissipated any part of the estate, and thereby precipitate a liability. Furthermore, the procedure under such a statute is generally cumbersome and more or less expensive, involving the taking of testimony. While such a statute may be of advantage in some cases, it is generally not prudent, in passing on an application, to put any dependence in it. There are many cases which may be accepted where there is a satisfactory provision for release, but which would have to be declined where there is no such provision. Where the bond is to continue in force only for a short time, the matter is not so important. But where the bond will be in force for a long period, as in the case of guardians of young children and the like, it will often happen that a risk, which appeared to be good when the bond was signed, will turn out to be undesirable before the termination of the trust. In considering applications for such bonds, In states where there is no satisfactory provision for release, great care ought to be exercised, and they should be issued only for applicants of the highest class, or where strict joint control is obtained. The limitations upon the power of a probate court to release a surety for a fiduciary, and the effect of the giving of a new bond by the fiduciary are matters which are very often misunderstood. It may be well, therefore, to make it perfectly clear, even at the expense of some repetition, 1. That a surety for a fiduciary can be relieved of liability only when the method, if any, pointed out in the statute has been strictly followed. 2. That the mere giving of a new bond by a fiduciary has absolutely no effect upon the liability of the surety on the original bond, except perhaps to make the sureties on both bonds jointly liable. And 3. That, where the statutory provisions for release have not been strictly complied with, an order of the probate court, directing that the surety on the original bond be released is absolutely void. The fact that so many people fail to understand and appreciate these three propositions leads to many complicated and embarrassing situations. It often happens that a fiduciary tires of paying the annual premium to the surety company, or objects to the surety company's requests for information, and thereupon files a new bond with personal sureties and refuses to pay further premiums, contending that the original surety is released by the filing of the new bond. He consequently feels that the surety company is trying to gouge him when it demands that the premium be paid or that a valid statutory release be obtained. If there is no statutory provisions for release, the surety must of course carry the liability and ought therefore to be compensated. Where there is a provision for release, and the surety attempts to obtain a release by petition, the principal often refuses to file another bond, contending that the bond already filed is sufficient. That bond however is not sufficient, for the statute provides that a bond must be filed in response to the petition, and a bond filed prior to the petition does not meet the requirements of the statute, and it often happens that the court having jurisdiction will agree with the principal and refuse to compel him to file a new bond. That leaves the surety with no alternative but to carry the liability without compensation or to sue for the premium. Sometimes a case is further complicated by the fact that, notwithstanding the statutory procedure has not been followed, as where the court accepts as satisfactory a bond filed prior to the petition, the court orders that the original surety be released. It is then particularly difficult to get a valid release, for generally neither the principal nor the court will make another move in that direction. It may be hard for a layman to understand that an order of court, directing that a surety be released, is not valid, but, where the statute has not been strictly complied with, the invalidity of such an order has been declared by the courts in too many cases to be now open to dispute.